Hey everyone. Over the last few days, we've been hearing about Justice Clarence Thomas's concurring opinion in a recent Supreme Court case. His opinion called for big tech platforms to be treated as utilities, specifically as common carriers, which would effectively bar them from censoring any speech whatsoever. A few years ago, some YouTubers, including Styx, called for this same solution, and I respectfully and strongly disagreed. At that time, I believed that designating big tech social media platforms as utilities would confirm their status as monopolies rather than regulate them. This solution doesn't address the many injustices done under the near-complete protection of Section 230 of the Communications Decency Act, which big tech has used as a legal shield to avoid accountability for their hundreds of millions of violations of Americans' free speech rights. If there's a pandemic today, it's a pandemic of corporate communist censorship, with YouTube and Google just being a few of the guilty parties. Today, while I see the wisdom in Justice Thomas's view, I still disagree on those grounds with the following caveat. If big tech social media platforms are to be designated as common carrier utilities, Section 230 of the Communications Decency Act still needs to be repealed, because if we turn big tech platforms into common carriers, Section 230 becomes a relic and thus unnecessary. Further, by failing to repeal Section 230, big tech will still use it as an unethical justification to protect themselves from censorship accountability in the courts. And because so many of our court justices today have traded in courage and ethics in favor of anti-constitutional and even outright communist activism, this will create potentially decades of additional unnecessary litigation that could be avoided were Section 230 repealed. While related, this isn't the subject of this video. Justice Thomas's opinion also stated that big tech social media platforms could be treated as places of public accommodation. This is something that I've been saying since I originally filed my lawsuit against Google and YouTube in August of 2019. With that in mind, let me share with you some of the reasons I support treating YouTube.com as a place of public accommodation. These excerpts are from my appellate court briefs before the Ninth Circuit Court of Appeals, and these arguments have never been made before in this way. They're also public record on Pacer and likely elsewhere if you want to download and read them for yourself. YouTube.com is a place of public accommodation. In the case at bar, the magistrate below applied an archaic 20th century and honorously literal analysis of this issue by limiting 42 U.S.C. subsection 2000A's application to physical places only. Now, that is the public accommodation law under federal statute. Instead, Lewis requests this court to apply the same level of 21st century conceptual analysis the United States Supreme Court applied in Packingham v. North Carolina when it found that social media platforms were digital public squares worthy of First Amendment protections. While the magistrate below found the primary controlling case to be Clegg v. Cult Awareness Network from 1994, the Clegg court didn't have the benefit of the Packingham court's analysis, which occurred 23 years later in 2017. The same holds true with the court's analysis of Noah v. AOL Time Warner Incorporated from 2004 by virtue of Packingham occurring 13 years later. Further, the Clegg, Noah, and eBid cases, that's eBid versus Facebook from 2019, while dealing with the issue of public accommodation generally, are factually distinguished because none of these cases dealt with online public theaters of the kind owned and operated by the defendants in the case at bar. The defendant's website, youtube.com, as pled in the SAC, that's the second amended complaint, sells and rents movies the defendants allow to be viewed through their website, youtube.com. In fact, once purchased, youtube.com is the only place these purchased movies, TV shows, and videos may be viewed by their purchasers. The defendants have never disputed this. This is contrasted by the fact that the defendants in Clegg, Noah, and eBid cases do not run online theaters. Further, the Clegg, Noah, and eBid cases are also distinguished because the plaintiffs in those cases never alleged national origin discrimination. This case does. Additionally, while the magistrate's decision below cites Ramirez v. Petrillo as relevant, Ramirez was misapplied because it's also factually distinguished from the case at bar in many ways by virtue of the pro se plaintiff suing a doctor who ran a private medical clinic because in part he misdiagnosed her, not on the basis of national origin discrimination, but rather racial discrimination. Further, because the Ramirez court involved a medical clinic, it found that 42 U.S.C. 2000A excluded medical clinics as places of public accommodation. To be clear, the case at bar does not involve a medical doctor, malpractice, or a medical clinic, either as causes of action or real parties of interest. Therefore, With the Packingham Court analysis and its finding that social media websites are digital public squares where speech is constitutionally protected in mind, Lewis believes the appropriate standard of review is to apply a two-pronged test to determine whether or not the defendant's websites are places of public accommodation. First, the court should analyze the defendant's conduct and then look to court or legal precedent and other related areas of law to see if websites or social media platforms have ever been found previously to be places of public accommodation. In this context, Lewis addresses the second prong first. Because this controversy involves a question of whether or not a social media website that's primary business is to exhibit, sell, or rent movies as a place of public accommodation and national origin discrimination against American citizens, it is a case of first impression. Therefore, there's no controlling precedent that's entirely on point which addresses social media website theaters as places of public accommodation pursuant to 42 U.S.C. subsection 2000A. However, there is plenty of precedent determining websites as places of public accommodation under the Americans with Disabilities Act, which, while not controlling, is definitely instructive in this analysis. With that in mind, this circuit in 2019 stated that no individual shall be discriminated against while at any place of public accommodation by any person who owns or operates such a place of public accommodation. The court stated that they agree with the district court that the ADA applies to Domino's website and app in Robles v. Domino's Pizza in 2019. Further, the First Circuit Court's decision in Car Parts Distribution v. Auto Wholesalers Association held that places of public accommodation are not limited to physical structures, and that case was in 1994. The Car Parts Court explained that it would be irrational to conclude that persons who enter an office to purchase services are protected from discrimination, but persons who purchase the same services over the telephone or by mail are not. Congress could not have intended such an absurd result. The plaintiff, that's me, contends the Car Parts Court's reasoning applies with equal force in the case at bar to services purchased over the internet, such as movie and TV show exhibition, sale, and rental services sold and or otherwise offered by the defendant's website, youtube.com. Lewis further perceives that in a society where American citizens increasingly conduct business online, especially during a pandemic, excluding businesses that sell and or otherwise offer exhibition of movies and TV shows through internet websites from being places of public accommodation runs afoul of the purpose of 42 U.S.C. 2000A and would severely frustrate Congress's intent that individuals have the ability to fully enjoy the goods, services, privileges, and advantages available equally to other members of the general public, free from discrimination, whether or not these services were purchased online or in person at a brick-and-mortar location. Even California's Civil Code, Civil 51B, makes it unlawful for businesses of any sort, whether located online or in the real world, to discriminate based on national origin. Even in the venue in which this case was originally filed, Colorado, their case law also makes discrimination based on national origin unlawful, and it applies to electronic communications such as internet websites. In fact, that law is CRS 2434-601A, and I'm not going to read it. You can see it there. Now, let's address the first prong of the test. The defendant's conduct in contractual terms affirmatively and expressly stipulate their de facto places of public accommodation by virtue of their contractual agreement containing the following provision. Our products are platforms for free expression. We don't support content that promotes or condones violence against individuals or groups based on, and this is relevant, nationality. Also, the defendants do not dispute that the second amended complaint factually alleges that YouTube.com offers closed captioning and other ADA accommodations for disabled users. The only factual difference between YouTube.com and a physical place of public accommodation is that YouTube.com's theater exists online and not as a brick-and-mortar location. In all other aspects, YouTube.com completely fits the definition of a theater under 42 U.S.C. subsection 2000A. Thus, Lewis contends under this two-pronged test, the defendants own and operate an online place of public accommodation that supports the claim that YouTube.com can be held liable for discrimination based on national origin. Now, with that said, I continue this argument in my reply brief, where I state, defining the defendants' websites as a place of public accommodation serves a compelling public interest. While the plaintiff stipulates that many circuits, including this one, have limited the definition of places of public accommodation to physical locations only, the plaintiff urges this court to consider the defendant's online theater, YouTube.com, as a place of public accommodation by virtue of the fact that that doing so satisfies a compelling public interest in a post-COVID world. Specifically, the plaintiff is requesting this court to consider the fact the United States is in the midst of a pandemic that has not only shut down major portions of our economy, but as a result has permanently destroyed many businesses, including physical theaters. Truly, the COVID-19 pandemic has changed the American way of life by virtue of social distancing mandates that limit Americans' ability to patronize many types of physical businesses. However, online businesses are booming, including but not limited to online movie theaters, such as the ones run by Disney, Amazon Prime, Hulu, and of course, the defendant's theater, YouTube.com. The defendants have never disputed that while they're a social media website, they're also an online theater. They publicly offer movies for sale and rent in addition to allowing their users to view videos for free. With this in mind, the plaintiff contends that by refusing to consider websites as places of public accommodation in a post-COVID world during a pandemic will result in a manifest injustice that will not only continue to irreparably harm the plaintiff, but hundreds of millions of other Americans, as social media websites offer services for sale, will be able to continue to discriminate and violate American civil rights without recourse because of a continued archaic and honestly literal 20th century interpretations of civil rights law that allows it. While I'm aware and commend Laura Loomer and Larry Klayman of Freedom Watch for filing their suit against big tech alleging their places of public accommodation, unlike my briefs, their pleadings before the appellate and Supreme Courts failed to argue any compelling reasons why the courts should define big tech social media platforms as places of public accommodation beyond making conclusory statements. More specifically, unlike my lawsuit, they failed to use current public accommodation law to link the services provided by big tech platforms to legally well-established brick-and-mortar places of public accommodation that already exist. Also, unlike my case, Loomer never called for the repeal of Section 230, which, given her public comments on this issue, I find extremely surprising. Had they taken these extra steps, I believe their case would have been far stronger. Regardless, both of these cases are cases of first impression and aren't likely to win. In fact, Loomer recently lost her case before the Supreme Court. But the good news is this. Since I challenged Section 230 on constitutional grounds and served the former Attorney General Barr with my lawsuit, the last administration, the Trump administration, started bringing this to the public's awareness. And now, even though these court cases are currently losing, even the judges are now speaking openly in favor of protecting the First Amendment from corporate communist censorship. So with that said, I'm DDJ, and this is your dose of misandry today.